The number was $387,000. That's what my mother-in-law said the house was worth when she stood up in the corridor outside Courtroom 4B and told her son, loud enough that the court clerk could hear, that I'd be lucky to get half. She was smiling when she said it. That particular smile she'd had for 11 years. The one that showed just enough teeth to signal that she knew something you didn't, and that the knowing was the point. She was still smiling 3 minutes later when I signed the paperwork. She had not read what was attached to it. Welcome back to Family Revenge Stories New, the channel where quiet people keep the receipts, and family learns that boundaries have a price. If stories about dignity, documents, and what happens when you underestimate the person who handles the numbers for a living speak to you, drop a comment and subscribe. I'll be here. My name is Naomi. I'm a forensic accountant. I have been for 14 years. What that means in plain English is that I find the money people have hidden, the money people have lied about, the money that was moved on a Tuesday night and then forgotten until I remember it for them. I work with law firms, I work with courts, and occasionally I testify in cases where the dollar amounts are large enough and the lies are specific enough to require someone like me. People in my profession have a saying, there is no such thing as a clean set of books. There is only the depth of the audit. I met Daniel at 31. He was soft-spoken and careful with money, and he laughed at things that were genuinely funny instead of performing laughter the way some people do. We were married within 2 years. We bought the house on Clement Street in year 3. A craftsman bungalow with original hardwood floors, and a kitchen that needed everything and a backyard that needed nothing. I did the mortgage analysis myself. I knew what we were buying and what it would cost and when we would own it outright. I put $62,000 into the down payment. That number is not in dispute. It came from my savings, 7 years of them, and it was documented in the wire transfer records and the HUD-1 settlement statement and the closing disclosure. I know this because I kept all 3. Daniel's mother, Renata, lived 40 minutes away in the house where Daniel grew up. She was a woman who had opinions the way some people have furniture. Everywhere, arranged to impress, occasionally blocking the natural light. She had strong views about how Daniel should spend his money, where he should live, whether the kitchen renovation I wanted was excessive, and whether I was, in her word, practical enough for her son. I was the one paying the mortgage. I was also the one who filed their taxes every April. Hers and Daniel's father's, Gennaro, who had died the January before Daniel and I married. I did it because Daniel asked me to and I said yes, the way I said yes to most things in those first years, believing that effort was the same thing as belonging. It wasn't. The family dynamic worked like this, Renata decided. Daniel deferred. His sister, Claudia, who lived an hour and a half north and appeared at Christmas and family emergencies in roughly equal proportion, agreed with Renata on every matter that did not affect her directly and disagreed loudly on the ones that did. There was a cousin, Marco, who said very little but watched everything. I noticed him. In my experience, the quiet ones in any room are either harmless or significant, and Marco was the kind of quiet that sits at the back of a courtroom and takes notes. I was the one who drove Renata to her cardiologist appointments after Gennaro died. I was the one who handled the insurance claims when her roof needed replacing. I was the one who sat with Daniel during the nights he couldn't sleep in the first year of grief and didn't say anything useful because there wasn't anything useful to say. That is the arithmetic the family ran on me for 8 years. Not maliciously, or not only maliciously. Mostly just because I was there and I was competent and they had mistaken my competence for an inexhaustible resource, the way people mistake rivers for permanent things until the drought comes. The drought, when it arrived, had a date, March 14th. That was the night Daniel sat down at the kitchen table on Clement Street with the hardwood floors I had refinished and told me he wasn't happy. He used careful language, the language of someone who has rehearsed. He said he had been thinking about this for a long time. He said he didn't want to hurt me. He said the word growing in a way that suggested he meant it as a verb applied only to himself. I sat across from him and I did not cry and I did not yell and I did not say the things I could have said. I went to bed and I lay there and I looked at the ceiling and I thought about what the forensic accountant in me had always known and the wife in me had never wanted to name. That the emotional ledger of this marriage had been running in deficit for years and I had been advancing credit. The next morning I made coffee and I opened my phone and I went to the recordings folder. I had been keeping voice memos for 3 months. Not covertly and not strategically. I kept them because I am someone who documents things the way other people breathe. Dates, times, what was said, what I observed. The memo from February 9th, the night Renata came to dinner uninvited and told Daniel that the house was not in a good school district, for the grandchildren she had not been told were coming. That was in the folder. The text thread from February 22nd, in which Claudia wrote to Daniel and not to me about our anniversary plans, referring to me as your wife in quotes, as though the marriage were a theory rather than a fact, that was screenshotted and saved. I did not know yet what I was saving for. I just knew I saved. I called my divorce attorney that morning. Her name was Patricia. I had actually done forensic accounting work for her firm 2 years prior, and when I explained the situation, she listened without interrupting, and when I was done, she said, "Do you have paperwork on the down payment?" I said yes. She said, "Good. Get it out." What happened in the 4 months between March and the court date in July is what people call a divorce, but what it actually is, in mechanical terms, is a negotiation over documents. Who has which document? What the document says. Whether the document says what the person claiming it says it says. I am very good at this. Daniel retained an attorney named Greg, who was younger than Patricia and spoke quickly, and had the particular confidence of someone who has not yet been surprised by a case. Greg sent a proposal in late April. It described the house on Clement Street as a marital asset to be divided equally. $387,000 appraised value, 2 equal shares. He did not mention the down payment. I sat with that proposal for 45 minutes at my kitchen table, the one Daniel had taken to storing boxes under because he had already begun the invisible process of leaving before the physical one. I read the proposal 3 times. Then I went to the filing cabinet in the second bedroom and I pulled out a folder I'd labeled home/purchase at the time of closing, and I found the wire transfer record and I found the HUD one and I found the closing disclosure, and I paper-clipped them together and I set them on the table. $62,000. My money. Premarital, documented, clean. In this state, that is not a marital asset. It is a separate property contribution to a marital asset, and it is recoverable upon dissolution. Patricia had known this from the first phone call. So had I. The question was whether Greg had missed it or was hoping I had. I found out 2 weeks later when Patricia sent the counter-proposal. Full credit for the $62,000 separate property contribution, off the top before the split. That left $325,000 divided 2 ways. Daniel's share. $162,500. My share. $224,500, which is $162,500, plus $62,000 recovered. Greg's response was 3 sentences long and contained the word aggressive. Renata's response was delivered in person. She came to the house on a Wednesday evening in May without calling. I heard the car in the driveway from the kitchen, and I recognized the sound of the engine the way you recognize patterns you never intended to learn. I did not move from where I was standing. I let her knock. She stood on the porch and she told me, with the precision of someone who has been thinking about what they want to say, that I was taking advantage of her son. She said I had gone into this marriage with an agenda. She said the house was Daniel's home too, and that she wasn't going to stand by while I manipulated the courts with paperwork that didn't mean what I thought it meant. I looked at her. I said, "Renata, do you know what the HUD-1 settlement statement is?" She said she didn't see what that had to do with anything. I said, "That's okay." And I closed the door. I called Patricia the next morning and said, "Send the letters." She sent the formal demand letter that afternoon, citing the 3 documents by name and by date, and requesting Daniel's acknowledgement of the separate property contribution within 10 business days. The 10 business days passed. No acknowledgement came. If you have ever watched people who couldn't find 20 minutes to help you move furniture suddenly develop extensive legal opinions the moment a settlement figure appears, you already know where this story is going. Stay with me. Here is what Renata did not know about Gennaro. I had filed his taxes for the last 4 years of his life. In doing so, I had become, in the dry language of financial record-keeping, someone who knew his affairs. Not because I was intrusive, I was not, but because tax returns are documents and documents tell you things whether or not you ask them to. Gennaro had a life insurance policy. A term policy purchased in 2004 renewed twice. It paid out $240,000 at his death. I knew this because the 1099-R appeared on the return I filed for that year. What I had not known, and what Daniel had not told me, was who the beneficiary was. I found out the way you find out most things in a divorce, through discovery. Patricia requested financial disclosures in early June, standard procedure. Among them, all insurance proceeds received within the last 5 years. Daniel disclosed the $240,000. He listed himself as the sole recipient. He did not list when it had been deposited or where, but Patricia had a subpoena and the bank had records, and the record showed a deposit on March 9th, 5 days before Daniel sat down at the kitchen table and told me he wasn't happy. 5 days. I sat with that number the same way I sit with a discrepancy in a financial audit. Quietly, letting it settle into context, understanding what it meant before I allowed myself to feel what it meant. He had received $240,000. He had deposited it. And then 5 days later, he had come to me with his rehearsed language and his careful face and told me he'd been thinking about this for a long time. The account it was deposited into was not our joint account. It was an individual account I had not known existed, opened the previous November. That is the timestamp I need you to remember. November, the account opens. March 9th, $240,000 arrives. March 14th, he sits down at the kitchen table. Patricia added the $240,000 to our asset disclosure requests immediately. Under this state's equitable distribution laws, funds received and concealed from a spouse during the marriage are subject to inclusion in the marital estate, particularly when the concealment appears deliberate. That word, deliberate, had a document attached to it now. The account opening date, the deposit date, the conversation date. Greg went quiet for 11 days. When he came back, he proposed mediation. We accepted. The mediation lasted 1 session. Patricia laid out the documents in order: the HUD-1, the wire transfer, the 1099-R, the account opening record, the deposit record, and named each one and what it showed. Greg looked at Daniel across the table and Daniel looked at the window and the mediator looked at her hands. The agreement that was reached credited me with the $62,000 separate property contribution and placed the $240,000 life insurance proceeds into the marital estate for equitable distribution, which, given the concealment, the mediator weighted in my favor. My share: $193,000 from the insurance pool, in addition to the $224,500 in house equity. Total: $417,500. The agreement was drafted and signed and scheduled for court approval on July 22nd. July 22nd. Courtroom 4B. Renata came because Daniel invited her, which told me everything about the judgment that had governed the past 8 years. She dressed as though it were a lunch, not a legal proceeding, and she sat in the gallery row with her handbag on her lap and her chin level in the way of someone who expects to be given good news. The paperwork was presented to the judge for approval. In divorce proceedings, this is largely procedural when both parties have agreed. The judge reviews the settlement agreement and the supporting documents and signs the order. There was, however, an attachment. Patricia had included, as Exhibit C to the settlement agreement, the full forensic summary of the concealed account, the opening date, the deposit date, and a 1-page timeline showing the sequence of events. This is standard practice in cases involving concealment. It becomes part of the court record. The judge reviewed it. She did not comment on it from the bench. She asked both parties to confirm they had reviewed and understood the agreement. We confirmed. She signed. I signed my copy of the settlement agreement on a small table near the clerk's station, outside the courtroom in the corridor. Renata was standing 6 feet away. She was smiling that smile. She said something to Daniel. I didn't hear it, but I saw his face, and his face had the particular quality of a person who has been told they've won something they haven't fully counted yet. I signed. I handed the pen back to the clerk, and I walked out. The gathering happened 9 days later. Claudia organized it, which was fitting because Claudia organized things the way she engaged with most situations, with maximum effort and minimum understanding of the underlying facts. It was held at Renata's house a Sunday afternoon, and I received an invitation by text, from Daniel, not from Renata. That described it as a chance for everyone to move forward. I knew what it actually was. It was a curtain call for a performance they believed was over. The home sold, the numbers settled, Renata's narrative confirmed. She had assessed me correctly, she had been right about everything, and the legal system had arrived at the same conclusion she'd held all along. I accepted. I brought a folder. The folder contained 4 documents, printed on clean white paper, paper-clipped in order. I had labeled each one with a small post-it in my own handwriting the way I label things in client files. Exhibit A, Exhibit B, Exhibit C, Exhibit D. Old habit. The habit of someone who knows that a document only works if the other person can follow it. I arrived at 2 o'clock. There were 8 people in the living room: Renata, Claudia, Daniel, Marco the quiet cousin, and 4 others I knew less well. A family friend, Daniel's aunt, 2 people I recognized from the wedding. Renata had made coffee. There was a cake on the sideboard which I found remarkable. I sat down. Renata waited approximately 4 minutes before she began. She spoke the way she always spoke when she had rehearsed, from the middle of a thought, as though the context were obvious, as though everyone in the room already agreed. She said that what had happened was a shame. She said I had come into her son's life and taken things that weren't mine. She said the house on Clement Street had been Daniel's future, and that I had leveraged the courts to take more than my share. She said this in the tone of someone delivering a eulogy for a version of events that she believed everyone in the room would ratify. She finished. She looked at me. I asked if I could say something. She said with some grace that she supposed so. I opened the folder. Exhibit A. The HUD-1 settlement statement from the original home purchase in 2015, showing my $62,000 down payment as the sole source of the down payment funds, with my name as sole contributor. I set it on the coffee table. I named it. I said, "This is the document that established my separate property contribution to the home. It has been in my files since 2015. Renata said that Daniel had contributed to the home for 8 years. I said, yes. His contributions are documented in the mortgage payment records, which were also included in the settlement. His share reflects them. Exhibit B. The 1099 are from Gennaro's life insurance policy, showing the $240,000 payout to Daniel, dated the year of his father's death. I set it down. I said, "This is a document I prepared during the course of filing tax returns for this family. I want to be clear, I did not use this as leverage. I included it in discovery because it is a marital asset and omitting it would have been improper." Daniel was looking at the table. Claudia said, "That money was from their father." I said, "It was. And it was received during our marriage and deposited into an account that was opened 4 months before Daniel initiated divorce proceedings. That sequence is what the court record reflects." Exhibit C. The account opening date, November 11th. The deposit date, March 9th. The conversation date, March 14th. I set the page down without naming each date aloud. I let them read. The room was quieter than it had been. Renata said, with less certainty than before, that I couldn't know what Daniel's intentions were. I said, "You're right. I don't know his intentions. The court record reflects the sequence. The settlement reflects the court's assessment of the sequence." Exhibit D. This was the one I had saved. In the course of preparing estate documents during the marriage, I had helped Daniel draft a will in 2019. Another thing I had done because I was asked, I had come across a letter that Gennaro had written. It wasn't a legal document. It was a handwritten note, 2 pages, addressed to Daniel, found in the file folder Gennaro had labeled important/keep. I had copied it when I organized the file. I had kept the copy the way I keep everything, in a folder labeled dated. Gennaro was not a man who said much. The letter was brief by most standards, but there was one line in it that had stayed with me since 2019, that I had thought about on March 14th and on March 9th and on every day of the 4 months between. I read it aloud. He had written, The people who show up when there's nothing to gain are the ones worth keeping. He had written it about me. I know because he put my name in the sentence. I said Exhibit D on the table. I looked at Renata. I looked at Daniel. I did not look away first. Marco, from his chair in the corner, said quietly, "She's right." No one acknowledged him. But no one contradicted him either. I said one thing before I picked up my folder. I said, "I want you to know that I understand why each of you told yourself the story you told. I've worked with enough numbers to know that people always have a version that makes the balance sheet come out clean for themselves. This is just the version that comes with source documentation." Picked up my folder. I left. The house on Clement Street sold on September 4th. The closing produced $417,500 in my name, net of costs. The funds cleared on September 7th. On September 8th, I did two things. The first, I transferred $15,000 to the nonprofit that Gennaro had quietly supported for the last decade of his life, a program for first-generation college students in the district where he had grown up. I had found it on the charitable contribution schedule of his 2017 return. I didn't tell anyone I was doing it. I didn't post about it. It was not a statement. It was just the right thing. The second, I put an offer on a house. A smaller one, with original hardwood floors and a kitchen that already worked. As for the others, Daniel and Greg reached a settlement with Patricia over attorney's fees related to the concealed account disclosure, the terms of which are confidential. What is not confidential is that Daniel is no longer in the house I paid for, and the account opened in November has, per public court records filed as part of the final decree, been accounted for. Claudia sent me a text in October. It said in full, "I didn't know about the account." I believe her. I didn't respond, not because I was punishing her, but because I had nothing to say that the documents hadn't already said better. Renata has not contacted me. She has told at least one person in the family that I weaponized paperwork. She is not wrong that I use paperwork. She is wrong about the weapon. The paperwork was never a weapon. It was just the truth organized. Marco sent me a card at Christmas. No message inside. Just his name. Kept it. Gennaro's letter is in a new folder now. It sits in the filing cabinet in the second bedroom of the smaller house with the original hardwood floors. The folder is labeled the same way I label everything. Clearly, specifically in my own handwriting. It says keep. I have thought about that word a great deal in the months since. What we decide is worth keeping. What we allow to be taken from us and for how long before we stop allowing it. What documents exist that say, plainly and in the language of record, who showed up and what it cost them. I count things for a living. I always have. I counted what that marriage cost me, not in grief, which is not a countable currency, but in actual things. Time, labor, presence, $62,000 documented on a HUD one. I counted what was hidden from me and when and in what sequence. And I counted what I was owed, not as the performance of injury, but as the plain arithmetic of what the records showed. Calm is not the same thing as weak. My family, and yes, I mean Daniel's family, but in those 8 years they were also mine, had confused the two from the beginning. They kept waiting for me to raise my voice. I just kept raising the documents. If this story reminded you that what you did shows up somewhere, in a document, in a timestamp, in the sequence of events that can be laid out on a table one page at a time, then you already understand what I think. And if you've spent time being the practical one, the one who handles the paperwork and drives people to appointments and files the returns and shows up without being asked, and you've watched that effort get mistaken for weakness or availability or something that can simply be assumed, then you already know the feeling I'm talking about. You don't have to perform your outrage. You don't have to make a speech. You just have to know where the files are. Drop a comment if this one found you at the right time. Hit subscribe if you want to stay. And update whatever needs updating in your files, in your boundaries, in what you're willing to keep advancing credit for. I'll see you in the next one.